Good evening, everyone. Thanks for joining us for the July 2021 monthly labor law update. Um, there are not many amendments for this month. It's just that the rules are being floated by various state governments. So the Himachal Pradesh government has floated the wage rules under the wage code. The Goa government has amended certain applications and things to be done under the Factories Act. And the medical officer's examination has to be done by the medical officer once in every 5 years. And certain small changes have been brought in by the Goa government. Except for these, there's not made any major legal changes that have happened in this month. The government has extended this ESA scheme where up to 90 days salary can be claimed, has been extended for a further period. So any employee who remains unemployed can claim benefits for up to 30 days under the ESA Act. The West Bengal government has revised the rates of minimum wages for shops and commercial establishments. Keeping with what we normally do is what is the OSH code, how many days the applicability has to be done for a date. This is one of the news we thought we'll share with at least our listeners from Tamil Nadu, that we have a new labor commissioner. Many companies today are looking at returning of employees to work after the COVID wave. And then when we look at it, there are very innovative things that people are doing to see how they manage with the COVID situation. So they have hybrid working models. And one interesting one was where if you come 2 days this week, or you could come 5 days this week and you don't need to come nothing at all next week, or different kinds of models are being experimented by companies on this COVID situation on how to get back people. And they're very cautious, and it all starts at a later point of time from September or so. Our knowledge corner for this month is also going to be COVID related. As you all know, the vaccination is a big issue. There are different types of vaccines that are being approved, and questions are being asked on the guidelines that are being framed. Central government has framed, given some directions, and then you have the state governments also coming down with guidelines on vaccination of employees at workplace, what needs to be done. There are many questions that have arisen, and so we thought this month we will try to address a certain questions, a few of them at least, that would be there in minds of our listeners. Vaccination of family members. So this is something that has been provided for. So all employees doesn't stop with employees, but their family members may also be offered vaccination. In fact, the government has said that it can be part of the CSR funds. So when you do not your employees, but their family, you can use your CSR funds. That's today's latest government circular. So you could use it for the funds for it. The next question that comes on this topic is, when you mean family, who is this family? Was it brothers, sisters, father, mother, or how it is to be taken? I think you can give a more restricted definition. You don't need to give a wider definition of family here. The family can be restricted to, first instance, to those who are living with the employee. So if it's a nuclear family, it's just the spouse and the kids. Or if it's a joint family, maybe the parents of the employee, but you don't need to be expanding it further beyond that. Some reasonable steps if you've taken, that's all is what the government is looking at. And it is not that you need to vaccinate everybody who's living with the employee. Is it mandatory or discretionary? Well, what is required of you as an employer is to make the vaccination available to all your employees who are willing. if any employee is not willing, we will see on that in the next slides. The question here is, as an employer, have you taken steps to ensure that your employees are vaccinated? And you would need to have sufficient material to show what steps you have taken in this regard. So that is the core question is, what steps have you taken as an employer? And you should be in a position to establish that you made available the vaccination to all employees and their staff. So that is what is required of this, the government guidelines. It is not, therefore you cannot mandate that an employee has to take it. It is certainly a discretion of the employee. What happens if an employee refuses? So the questions have come, can we dismiss the employee if he refuses to take vaccination or deny him employment? Unfortunately, Indian legal system does not permit an employer to refuse employment on the ground that he fails to get vaccinated. Yes, he is putting other employees at risk. It's a good cause, but unfortunately, the current system doesn't provide for it. So merely because an employee refuses to get vaccinated, you cannot take any action against the employee in this regard. Non-vaccinated employees, can you refuse to pay wages? No, certainly not. You cannot refuse on that ground. Maybe when it comes to a question of appraisals, you could consider that he was not a team player. He or she was not a team player, or whatever it is, and maybe could be a part of your appraisal. Maybe somewhere you could take that into consideration, but refusal of wages is certainly not permissible in law. There are no prescribed forms or registers, but as far as possible, if you could have maintained some records to show that you vaccinated your employees and you offered the other employees also, that is those who don't wish to get vaccinated, you have given them the opportunity to get vaccinated. So if you could have some kind of a form where you could just collect the details of the employee and an acknowledgement from him that you have made available the vaccination, but him, for his own personal reasons or medical reasons, he refuses to get vaccinated. In medical reason cases, if you can collect some material to show that it is for medical reasons that he is not vaccinated. Again, no disciplinary action can be initiated merely because an employee refuses to get vaccinated. I've already touched upon this slide. Try to collect a form where you could have the employee's signature saying that he was offered vaccination, but he refused to avail the opportunity that has been extended by you as an employer. Certain industries have followed certain things. They've taken to stand that a non-vaccinated, that is where an employee for non-medical reasons refuses to get vaccinated. Medical reasons is understandable. They don't want such employees to be traveling in the transportation, company transportation. Either they provide a separate transportation or they ask the employee to make use of public transportation. There are employers who have tried to give badges, vaccinated, non-vaccinated. So employees will be wearing badges saying that either they're vaccinated or not vaccinated. As I said, as a team player, he has not been a team player, and therefore there could be a small element of negative appraisal on that ground. Some employers have told non-vaccinated employees will continue to work from home and they would not be coming from home. Initially, all of us had this euphoria of being at home and working, but today more people want this hybrid of flexibility, and people want to come to office, interact with others, and a lot of social interactions are there. So it is not a great pleasure staying at work, staying at home and working all throughout. So work from home is also kind of a punishment these days, you could say. And then those who are not vaccinated are asked to take a weekly test, of course, at their cost. Something like that could also be possible. Lockout, the is more to bring out your attention that the fine amounts have been substantially increased under the IR code. And similarly, under the Social Security Code as well, the fine amounts, punishment amounts are substantially high, includes also imprisonment term up to 3 years. So the codes are going to be brought in at any point of time. The punishments under the codes are quite severe. This is a report, an interesting report of how a company has saved in billions because of people working from home, of course, and also the COVID, due to which promotions were not granted. And so if you look at this, the saving they say is around 1 billion for a tech giant. That's a very interesting report we thought we should share with you, how companies have, because of travel, entertainment, etc., have been able to save substantially. So positive sides of COVID. We always listen to the negative news on COVID. This is a positive news on COVID for companies. Another interesting debate we found in the social media was when you take a background verification check, a specific query could be put on how the employee worked during the notice period before he left, because he is well aware that he is to leave. And if despite that, even during the notice period, if his performance has been good, it reflects on his professional ethics and character. So we thought this is again another interesting thought to be left with all our audiences. This is a judgment on damages that the Madras High Court granted on sick companies. We have already dealt with similar cases in the past, so we won't dwell too deep into it. This is a case where the employee wanted to avail a private hospitalization. He was covered by the ESI. The ESI covered him to the extent possible, and then he wanted reimbursement of the expenses that he had incurred in private hospitals without the authorization. The ESI benefits were denied in this judgment by the Madras High Court. This be one more interesting case of where the complaint under the prevention of sexual harassment, the committee went into the complaint and they found that there was no harassment because whatever had happened was out of mutual consent. But they found the committee did make observations on inappropriate behavior on part of both the complainant as well as the respondent, and recommended for suitable action. The Delhi High Court has said that once there is no sexual harassment, the IC committee cannot grant any further directions, and therefore it can't act as a moral police, and the personal conduct of parties cannot be considered by the IC. So on that ground, the IC has set aside the order of, the High Court has set aside the order of the IC. This is not too, this judgment may not have much implication on private employment, but in public sector where you follow communal reservation, and if you have any doubts on the communal status of an employee, it would need to go through the caste verification committee. And merely because somebody else were to tell you, you could not take action. This judgment is a classic example of that. Provident fund, many times we find employers to find it very difficult to pay the amount. Sometimes, when you are, there's a cash flow issues or something. And this judgment where Kerala High Court has said that High Court does have the power under Article 226 to direct payment of Provident Fund contribution and dues in installments. This is a case where the employees, this could be very helpful to many, but in the sense where there is a contractor and then a new contractor comes to and takes over. The old employees filed a writ petition challenging, saying that either the principal employer should take them or the new contractor should take them, and the new contractor cannot bring his own workforce. In this case, the Delhi High Court, of course, had told them that they can't come by way of a writ petition and they should go before the ID Act. But it also observed that they had no legal right to claim employment with the principal employer or a re-employment with the contractor who no longer is available, nor with the new contractor. Sorry. We often these days find television news channels calling senior counsels for sharing their views on various aspects. So one such senior counsel appeared before the Madras High Court, and this is an anecdote from there, where the counsel informed the court that he's not going to take much time, less than a minute, he said, and then the repartee of the learned judge was that you're not in a debate, you're in court, you can take the time, all the time you want. This is the complaints calendar for the month of August. What needs to be done in August in different states by employers. Unfortunately, this time the slide, even in the first instance, had the answer highlighted. It was 60 days. So any employer who wishes to register, once the OSH is notified, would need to do so within 60 days. Thank you all for joining us for this July. We will meet again on 28th August at 4 p.m. Do stay safe till then. Thank you. Have a nice evening.